Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, performance test, writing the persuasive brief or motion, point headings, framing facts, and persuasive rule application. Let's begin. A persuasive brief or motion on the performance test asks you to advocate for a result. The audience is usually a court, agency, arbitrator, or other decision maker. Unlike an objective memo, the goal is not neutral prediction. The goal is to present the strongest legally supportable argument for your client while maintaining credibility and using only the provided file and library. Persuasion on the PT is disciplined. It does not mean ignoring the law, misstating facts, or using dramatic language. It means organizing the rules and facts so the desired conclusion feels legally necessary. You lead with your strongest points, frame facts favorably, distinguish harmful authority, and explain why policy or fairness supports your result. The greater rewards advocacy that is grounded in the closed universe. Point headings are central. A point heading is more than a label. It is a legal argument in headline form. Instead of reasonable notice, a persuasive heading might read, "The court should deny the motion because the landlord entered without reasonable notice and no emergency excused the entry." Persuasive fact writing also matters. The facts section should be accurate, but it can be framed. You may emphasize favorable facts, present chronology in a way that supports your theory, and use precise wording. You should not omit critical harmful facts that the court must know, but you can place them in context. Good advocacy earns trust. Start by identifying the requested relief. Is your client asking the court to grant summary judgment, deny a motion to dismiss, compel arbitration, suppress evidence, issue an injunction, award fees, or reverse an agency decision? The relief shapes every section. Write the requested result at the top of your outline. Next, determine the legal standard from the library. Persuasive briefs often turn on standards: likelihood of success, material dispute, abuse of discretion, good cause, substantial compliance, reasonableness, prejudice, or public interest. State the standard clearly and then use it to frame the argument. If the standard is favorable, emphasize it. If it is demanding, show how your facts satisfy it. Create argument headings that are complete sentences. Each major heading should state why your client wins. Subheadings can track elements or factors. For example, the injunction should issue because the covenant protects confidential customer routes and imposes only a narrow 6-month restriction. Subheadings might address likelihood of success, irreparable harm, and balance of hardships. Frame the facts around your theory. A theory is the simple reason your client should win. In a contract motion, the theory might be that the other side seeks to escape a clear written promise after receiving the benefit. In an employment motion, it might be that the employer punished protected reporting rather than enforcing a neutral rule. Choose facts that advance the theory. When stating rules, synthesize rather than dump. The court needs the governing test and the most helpful authority. Use cases as support for propositions and comparisons. For example, courts find substantial compliance where the notice served the statute's purpose and caused no prejudice, as in Lane, where the recipient had actual notice and responded before the deadline. Then show why your facts are as strong or stronger. Handle unfavorable facts directly, but strategically. If a bad fact is obvious, silence damages credibility. Address it in the section where it matters. Minimize fairly by explaining why it is legally irrelevant, outweighed, distinguishable, cured, or not supported by reliable evidence. For example, although the notice omitted the apartment number, the building manager received it, identified the tenant by name, and responded the next morning. Under Lane, the statute's purpose was satisfied. Distinguish harmful cases. Do not merely say they're different. Identify the factual or legal difference that matters under the rule. Ramos does not control because the tenant there received no written warning of the policy, while Green signed a separate acknowledgement in bold type. The distinction should connect to the library's reasoning. Use policy carefully. Persuasive PT libraries often include policy language. Use it to close gaps in close cases. If a rule protects reliance, explain how your client relied. If it prevents gamesmanship, show the opposing party's tactical delay. Keep policy tied to legal standards. Do not turn the brief into a speech. End each argument section with the requested action. Accordingly, the court should grant the motion. Clear asks matter. A brief is not complete unless the decision-maker knows what you want and why. Choose the order of arguments deliberately. Lead with the issue that gives the decision-maker the cleanest reason to rule for your client, especially if that issue could dispose of the dispute. Put weaker fallback arguments later and label them as alternatives. This ordering shows judgment and keeps the reader focused on the path to the requested result. If the task memo supplies a required order, follow it. Otherwise, organize from strongest and simplest to more conditional or fact-dependent. Suppose the task asks you to draft the argument section of a motion to compel a former employee to return confidential customer lists. The library provides a statute allowing injunctions to prevent misuse of trade secrets and cases defining reasonable secrecy measures. One case grants relief, where the employer used password protection, confidentiality agreements, and limited access. Another denies relief, where customer information was publicly available and shared broadly. A weak heading would say, trade secret. A strong point heading would say, the court should enjoin Rivera's use of the customer lists because Apex protected them with passwords, confidentiality agreements, and need-to-know access. The argument would state the statutory rule, synthesize the cases, and apply file facts. Rivera signed the agreement, accessed the list through a restricted portal, downloaded it 2 days before resigning, and emailed 3 listed customers from his new employer. The brief would address the weakness that some customer names appear online by arguing that the compiled purchasing history and pricing preferences are not public. The conclusion would ask the court to order return or destruction of the lists and prohibit use. The answer would feel like a motion, not a neutral memo. One mistake is using neutral headings. In persuasive writing, headings should argue. Another mistake is overstating. If you claim there is no evidence, when the file contains some evidence, credibility suffers. Students also bury their best facts. Put strong facts early and connect them to the legal standard. Some answers ignore harmful authority. A court expects you to address cases that appear contrary. Another mistake is writing emotional rhetoric instead of legal persuasion. The PT rewards rule-based advocacy. Draft point headings before full paragraphs. Good headings create the structure and may earn credit even if paragraphs are shorter than planned. Spend enough time on the library to know the standard, then move to writing. Persuasive products benefit from clear organization more than decorative language. If time is short, write the argument section first. A perfect caption or introduction is less important than legal analysis. Use concise facts, strong headings, and direct conclusions. A persuasive PT product advocates for a specific result. Use argumentative point headings that combine law, facts, and outcome. Frame facts accurately but favorably. Synthesize rules and compare library cases. Address bad facts and harmful authority strategically. End sections by telling the decision-maker what to do. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.